Hi, I'm Michael Krucker and I work with the Employee Benefits Consulting Group. I'm here to talk to you today about how to determine whether your employees are full-time or part-time. The employer health care penalty tax is made up of two taxes. The first applies to those employers that choose not to offer coverage to their full-time employees and their dependents. The second tax applies to those that offer coverage, but that coverage is unaffordable. So in order to determine which penalty taxes, if any, apply to your group, you must first determine the pool of employees that should be offered coverage. When determining which penalty taxes apply, if any, it's important to note that you're only looking at full-time employees. Unlike when you're determining whether you're a large or small employer, where you actually take part-time employees and convert them to full-time equivalents, here you're only looking at full-time employees. The statute defines full-time employees as those who, with respect to any month, work at least 30 hours per week. For administrative simplicity, an employer can define full-time employees based on monthly hours, using 130 hours per month as an equivalent of 30 hours per week. If an employer uses this rule, it should apply it on a reasonable and consistent basis. An employee for these purposes is any individual that is an employee under the common law standard. What this means is that leased employees, sole proprietors, partners in a partnership, or 2% S corporation shareholders are not considered employees. The method for calculating an employee's hours for any given week or month depends on whether the employee is hourly or salaried. If the employee is hourly, you'll need to count the hours for which you actually paid the employee. This would include work hours, vacation hours, sick hours, and so on. When calculating the hours worked for salaried employees, you generally have a few options. First, you can count the hours that you actually paid the employee. Second, you can use a day's worked equivalent, in which 1 day equals 8 hours. Or third, you can use a week's worked equivalent, in which 1 week equals 40 hours. Under the statute, determining an employee's status as full-time or part-time is done on an ongoing basis. In other words, on a weekly or monthly basis. This is in contrast to determining whether you are a large or small employer, which is determined by looking at the prior year and is locked in for the next year. The IRS recognized that this approach potentially creates administrative challenges for employers. Some potential issues include the need to track hours on a weekly or monthly basis, adding and removing employees from the plan month after month based on how many hours they worked, and so on. To remedy this issue, the IRS proposed regulations which provided safe harbor methods for determining an employee's status and locking it in for a defined period. If you've heard the terms measurement period, stability period, and administrative period, these terms are related to this safe harbor method. So the safe harbor methods are optional, but as a practical matter, they're likely the most efficient way for you to maintain compliance with determining who must be offered coverage. While there may be other methods that make more sense for your group, we recommend that you become familiar with the rules as they're likely your best option.